The final case that I have today is Sun Pharmaceutical Industries versus DWD Pharmaceuticals Limited. Again, November 2022 case. So this is a little tricky in terms of determining what kind of trademark is being actually infringing, because it's in class 5. So as we all know, class 5 is the mark for pharmaceutical products. And given the fact that most pharmaceutical compounds are named after chemical compounds, there's a lot of contention regarding the name. So the plaintiff's mark is Forzest, F-O-R-Z-E-S-T, which has been in use since 2003 and registered under class 5. The defendant's new mark, which was applied in 2022, was Folzest, F-O-L-Z-E-S-T. And it was applied again under class 5. And the defendant had contended that they have more claim over the mark Folzest because it belongs to a family of mark called Zest, which has been in use since 1983. Now, in this specific case, the balance of convenience was in favor of the plaintiff, meaning that the plaintiff's contention that Forzest and Folzest are very phonetically similar, but their uses are very different. The plaintiff's product is used to enhance fertility and cure erectile dysfunction in men, while the defendant's product, which is Folzest, is used to is a multivitamin used by pregnant women to avoid preterm miscarriages and preterm births. So given the critical use of both the products, the court was of the opinion that the second mark is infringing on the first mark. However, the case takes a turn because after an injunction had been passed in favor of the plaintiff, it was brought to the notice of the court by the defendant. There's a lot of misrepresentation which was done on the part of the plaintiff here. They had said that they were not aware of the mark until 2022. However, the family of mark Zest, which is being used since 1983 by the defendant, was well known to the plaintiffs, and they had concealed this fact to strengthen their case. And this case actually works as a deterrent and as an example to most of the people who are fighting cases, saying and asserting the principle of clean hands, saying that in case the defendant intentionally has not disclosed the above facts and therefore is guilty of concealing material facts, although the balance of convenience was in their favor, the case leaned in their favor. And to make an example out of it, the plaintiffs here, Sun Pharmaceuticals, were fined 10 lakh rupees in November 2022, as an example.